Hello there and welcome to this IBFD webinar. My name is Tamás Kulcsár. I'm the manager of international tax training at IBFD. Today's topic of discussion is recent international case law on permanent establishment. I have Emma Beauregard and Louise Noel here with me at our studio. Emma and Louise, thank you very much for coming and thanks for accepting our invitation. Emma is a senior associate at the IBFD and Louise a principal associate. Guys, would you mind introducing yourselves?
Sure. Yeah, thank you. Hi everyone, my name is Emma and I work here at the IBFD. I have a background as a consultant with one of the big four for the Nordic market. I've worked in Sweden and Denmark. I thereafter worked as in-house consultant for US multinational covering the Nordic market and later on transferred to Luxembourg to work with the EMEA tax planning team and joined IBFD for approximately 1.5 years ago.
Well, great to have you here, Louise.
Well, thank you very much for the invitation first. My name is Louise Noel. I'm a principal associate. My background is primarily as a tax advisor. I work in a couple of countries, including the Netherlands. I do also have experience as a treaty negotiator and in the tax administration. And I've been in IBFD for the last 11 years.
Okay, well, great to have you here again, and I'm sure that our viewers will benefit from your practical experience on the matter. A few technical tips and the technical features of this webinar are as follows. This is a live webinar and live video stream from Amsterdam studio. The webinar is scheduled for 1.5 to 2 hours. The actual length will depend on the number of questions, the level of interaction with our viewers. In case you have any questions, please use the chat bar, the chat functionality that is available on your monitor, and get in touch with us. We are going to actually forward the question to our experts who, if time allows, are going to answer that. We are going to also roll out and present poll questions throughout the webinar. So these poll questions will enable you to interact with us. In case you would like to receive a CP point from your local organization, and please answer those questions as well. In case you can't follow the webinar in its entirety, so you're unable to follow this 2 hours, there's nothing to worry about. You have the opportunity to get access to it via our tax research platform for 12-month period. At the end of the webinar, you can also download the slides if you have not received them. And we are going to ask you to fill in a survey to give your feedback about the webinar, the quality of it, the quality of the broadcast, the topicality of the webinar, and the performance of the presenter. So thank you very much again for joining us. Without further ado, I'm going to talk you through the agenda. Actually, today's webinar is split into 4 parts. We're going to start with recent case law. We brought you a wide range of cases concerning permanent establishment, both physical place of business, offices, premises, employees, warehousing. Then we move on essentially to sales and marketing activities and expatriates who are performing activities on behalf of foreign principals. The second point, the second part and section is dedicated to the recent OECD developments. As I think most of you know that the OECD a few weeks ago published an additional guidance on attribution of profits to permanent establishments. So we're going to look at it, what does it add actually to the conversation that has been done so far on Action 7 of the OECD BEPS report. And then the penultimate part is about the EU developments. I'm also sure that most of you know that the European Union and the European Commission actually precisely published 2 proposals for directives to tax digital economy activities. And one of them concerns a virtual permanent establishment, a significant digital presence definition and concept. This is completely new, and we're going to actually elaborate what does it mean, how it works, what is the reality actually that it becomes law at the end, and if it does, what is the impact on your structure. And then finally, we brought you also some examples of domestic unilateral measures which deal with international structures that are normally addressed via the concept of permanent establishment. So tax administrations really, in a normal case, would like to find in those structures permanent establishments, so there's a PE risk. On the other hand, these unilateral measures move the conversation away from that concept and address the problem via new types of anti-avoidance measures. And so we are going to talk about, of course, the UK and Australia's diverted profit tax and the multilateral anti-avoidance legislation also. So thank you very much. Again, if you have any question, please just get in touch with us. All right, so we're going to start our webinar actually with a poll question. And this poll question is as follows. Do you believe that the latest measures from the OECD and the EU will create a more equal playing field with regard to the creation of permanent establishment? So we are really looking at your understanding of the changes, the impact of the changes. Do you think that it makes sure that multinationals, corporates are going to pay the fair share of tax based and under this new provision? So I open the poll and the floor for you. So please click A if you agree. So you think now these new definitions and concepts, European Union, OECD, will capture actually value creation and profit is going to be taxed where it should be taxed. B if you think only to a certain extent, and C if you don't agree with it, so you think not at all. I'm going to leave a few seconds for our viewers to answer the questions. All right. So thank you very much for everyone who casted his or her votes. Let me just stop the poll and show you the result. Essentially, we have a tie, draw. 50% of our viewers believe that yes, the new measures will capture value creation and profit is going to be taxed where it should be taxed, so they will create an equal playing field, level the playing field, but 50% said it only to a certain extent. What do you guys think about it?
Positive to hear that we have viewers who believe in the system, and that yes is the one that I have chosen, of course. Yet to be seen, but of course it's a step in the right direction, and the question is whether or not it's sufficient, I would say.
Right. All right, Luis?
I agree with Emma. I mean, especially we need to give some time to see how this is going to play, how this is going to be implemented. And well, we have seen a little bit of cold feet when we look at the MLI, for example, and PEs and the new OECD rules for permanent establishment. We're going to speak about it a bit later.
All right, thanks, guys. So let's move on and discuss our first case. It concerns India and the Formula One race. Emma?
Yes, thank you very much, Tamas. So when we're talking about different case law, I think it's natural that we turn our heads towards India and we start to look at this Formula One World Championships case from April 2017. And it evolves around the Formula One World Championships Ltd, which is located in the UK and has all the commercial rights for these races, these car events. And in this case, it was an India company called JP that had paid $40 million for the right to host, stage, and promote the Indian Grand Prix for a period of 5 years. And in this agreement, it was also agreed that this UK company had the right to check that the circuits had the right criteria and the requirements, and they had to inspect and approve it before the races continued. Also, very importantly, this race is only 3 days per year, but it was also in part of this race promotion contract that they had the right to have access to the circuit 2 weeks before and 1 week after the race. So this was, of course, part of the discussion in the case. And it's a very good case to read to follow the 5-1 PE discussions, the fixed place of business. So they're basically going through all the criteria that is needed to be fulfilled in order to see whether or not it is a fixed place of business. And as you can see here, there's a circuit, and it's claimed then by the tax agency that they had a disposal of the circuit, and they had all the criteria needed in order to fulfill the 5-1 fixed place of business. And the only one that has been questioned also, but afterwards we saw the case, this is by the Supreme Court, by the way, is the permanency. So whether or not these approximately 3 weeks per year is enough in order to fulfill the criteria of permanence under 5-1 in the OECD Model Convention. In the case, it was determined that that was sufficient. They said that they had the characteristics of stability and dependence, and therefore it was determined that it was a fixed place of business.
Right. So Emma, if I understand essentially your analysis, it means that the foreign principal had first of all access and control over the place. So it had to dispose of the place as its disposal, which is an important criteria.
Yes.
Despite it's not in Article 5, right? So it's in the commentary. And on the other hand, the other question is really whether it's a permanent business presence actually in India to go there. And then if I read and if I remember actually the commentary correctly, it says that, well, you need a permanence that might be 6 months usually.
Yes.
That is some kind of the acceptable level. There are 2 exceptions mentioned. So, and one of them actually is when the activity is of recurrent nature.
Yes.
So there's time to time happening essentially in the period. Was this actually a text, or was this argued, or was this actually brought into the decision at all?
This was mentioned in the case.
Right.
The
Was there any
recurring
reference
activity.
actually to the OECD commentary or anywhere international guidance on the matter?
Not in this case, and it's interesting when you mentioned the 6-month rule. That was not mentioned at all in the case. So that was left outside, and that's also what has been criticized later on with the case that was not brought into attention. But the recurrent activity was mentioned, and the fact that it was under a 5-year period, and therefore then it should be stated as a stability or a recurring activity, and therefore it should be a fixed place of business for then the UK company in India.
All right. Okay. Well, thank you very much, Emma. Let's move on. We move to Italy. This is our second case, and it concerns fashion brands and industry. So, Luis, the word is yours.
Yeah, thank you very much, Tamas. This is a very interesting case, especially because how it was structured, the business. In principle, we have a company which was resident in Luxembourg, and this company was acting as a principal with a lot of functions, including marketing, sales, setting the price, negotiation of all the contracts with clients and customers. This company in Luxembourg, they had enter into a contract with a related party, which was a resident in Italy, and this was to be a limited risk manufacturer. So they pretty much manufacture on order from the company in Luxembourg all the pieces. They also provided warehousing services, and also they receive orders from customers. It is very important to mention that they only transfer the orders to the company in Luxembourg, and it is the company in Luxembourg the one that accepted or not the orders. When the court start looking at these, I mean, this is a bit of a twofold case because it has a criminal part, but let's start with the tax one first. The tax administration, they decided, or they found that there was a permanent establishment, and they look at Article 5.1. When you look at Article 5.1, there are a series of tests that has to be passed in order to have a permanent establishment. They pretty much didn't look at these tests. They just look at the activity carried in the Italian company. If you look at the test, at least you will need to have the place of business. This place of business has to be at the disposal of the company in Luxembourg, which was not the case. They just look at the activities carried in Luxembourg, and they split the case in, well, the case, no, they split the whole activity in two. The activities carried in Italy from 2002 until 2004, and in this case there was no permanent establishment. However, from 2005 until 2006, because the company in Luxembourg set up an IT system in the Italian company, they found that the combination of the activities of these 4 employees in the Italian company plus the IT system will actually generate enough business activity in Italy to trigger a permanent establishment, which I have to say it's a bit on the edge of what is a permanent establishment or not. Interestingly, in this case, there is a criminal part, and this criminal part has to do with because there was a permanent establishment, and that was appointed by the tax administration, that permanent establishment will have been required to pay taxes and declare taxes, but because the client didn't agree with this, there was not actually taxes paid, and that will constitute a criminal offense in Italy. So when the case arrived to the Supreme Court, the criminal chamber actually say, well, you know what, there is no criminal offense because there is no permanent establishment, while the tax chamber say, well, there is a permanent establishment because you have an IT system.
Right, thank you very much, Luis. A few questions actually from my side. So we indicate in the slide that there are 4 employees. They were officially actually employed by the Italian company, right? But they essentially, in practice, in substance, were working for the Luxembourg entity, since they were receiving these orders, these purchasing orders, and then I assume they were the ones that put the data into this IT technology system and then went up, right?
Yeah,
so
they were
providing,
they were employees of the Italian company, and they were the Italian company was providing the service to the company in Luxembourg.
And then if you look at the IT technology, I remember the case mentions that there's a server in Italy, so there's some kind of physical presence. Now, if you read the OECD commentary, it says even if there's a server in the source state, so the state of the investment or where the activities are going on, that can only create a permanent establishment if the activity that is going on actually in the cloud is a significant activity in terms of sales or something like that, service provision. So here is just this ERP or a CRM or business intelligence system just gathered the data, and then the data went up to the Luxembourg entity. Do you consider this as significant in any way?
I don't think that that's enough to trigger a permanent establishment. What the system was doing was simply the employees was pretty much typing the orders, so the orders were transmitted to the company in Luxembourg. There was no sales in Italy or any whatsoever, so the activity was very limited. So actually the taxpayer, one of the claims of the taxpayer in the whole process is that, well, the system was doing exactly the same what the employees were doing, which was faxing the orders to the company in Luxembourg. But because there was an incremental of the marketing from the company in Luxembourg and the sales, they needed this system to speed up the process.
Right, so I'm sure that they're happy that they gained efficiency and then created a permanent establishment. All right, that is really a great case.
And the question, of course, comes to then later on what profit is to be attributed then to the Italian company.
Yeah, I think we will deal with profit attribution, and we will see these cost centers or similar activities. How we attribute profit to them. Let's move to Russia. As I see in the slide, we have here a Dutch entity with a local distributor. Well, what is this case about, Luis?
That's a pharmaceutical company. The pharmaceutical company, part of is a large group, and one of the entities is in the Netherlands. This entity had a subsidiary in Russia that acted as a fully fledged distributor of all the products that were manufactured and imported into Russia. This Dutch company also had a representation office in Russia. And this is the whole key of the PE part, because this representation office was pretty much like in any other country in the world. If you want to sell medication or medicines in Russia, you have to register the medication, you have to conduct some clinical trials, and all that was done not by the distributor, but by this representation office. Plus, this representation office was doing market research and, well, a bit of marketing promotion for the branded products. The tax authorities, they decided that this office is to be a permanent establishment of the Dutch entity. And they did it on the grounds that the activities carried on by the permanent establishment were being utilized in favor of the activities of the Russian company. As you probably know, in the commentaries of the OECD model, activities that are in principle of a preparatory or auxiliary character, they're supposed to be done, are supposed to be performed just for the enterprise. But then the commentaries, they mention that if these activities are performed also for third parties, then these activities will not be considered as a preparatory auxiliary character. And that was the argument of the Russian tax authorities and the argument used by the Russian tribunal.
I mean, looking at the case, actually, the activities seem to be rather simple, right? And
Yeah.
those activities that we would say automatically exempt because it's about market research and promotion, so collection of information or pure promotion without sales. But indeed, there is this crucial condition that it needs to be done actually for the foreign entity and not actually for the local entity. So that was actually a mistake.
No, it's very interesting because, I mean, of course, the entity that was the owner of the permit is the Dutch entity. So they thought, okay, because I am the owner of the permit, well, you know, then the service was provided for me, not for the distributor. But then the tax authorities, they say, well, if you do marketing, for example, in Russia, who's going to benefit? Mainly, well, the distributor, because he's going to enjoy this exposure of the products that they're selling. There is another thing. If you look at the activities that are carried by the office, there is no income there. It's just expenses.
Yes.
And it got my attention. And when you read the decision, you see that they mention a rule. I think it's in Article 307 of the tax code in Russia, and that's a deemed determination rule. So if it's not possible to have a direct determination of the profits, what they're going to do is that they're going to consider as taxable income 20% of the expenses incurred by the PE.
Right. All right.
So it's kind of interesting how they actually managed to do the attribution.
Right. It's quite exciting. Okay, let's move on. I think the following case concerns Japan and the automotive industry. So, Luis?
Yeah, that's online case, digital economy. The case or the facts of the case is that we have an American company, a United States company, and this company was selling car parts in Japan, but they did it through a website. So it was a website hosted in the U.S. and that website had an online store where clients in Japan can purchase these spare parts. Funny thing is that the Japanese or the website actually looked and feel like a Japanese website, even though it was set it up in the US. The only physical presence that the US company had in Japan was an apartment and a small warehouse. And every time a customer made a purchase through the website, the American company will send an instruction to the employees to actually deliver the merchandise to the customer in Japan. Also interesting is that even the instructions in the parts were translated in Japanese, but the translation was done in the US office. So all the customers, they have the impression that they were dealing with a Japanese company, which is kind of interesting for something that we're going to mention now. The tax administration in Japan, they consider that the warehouse constitute a permanent establishment. Once you start looking at the definition of permanent establishment, well, you see that there was a fixed place of business. This place of business was at the disposal, of course, of the U.S. company. An activity, it was fixed, and there was an activity performed there. The question was whether that activity was considered to be of a preparatory or auxiliary character, or an activity that will trigger a permanent establishment in Japan. And that's exactly what the taxpayers say. The taxpayers say, you know what, this is a preparatory or auxiliary character. And they actually even look at the discussion draft that the OECD published in 2012. And that discussion draft actually mentioned that you don't need to have a preparatory auxiliary character. Any activity that was established in Article 5.4 was to be excluded, even if it was not a preparatory auxiliary character. That discussion draft was never, that was left aside because the OECD jumped into the BEPS project, and actually the outcome of the BEPS project actually contradicts what this discussion draft actually said. The court say that, well, this discussion draft cannot be taken into account. It is not considered to be a supplementary means of interpretation based on what the Vienna Convention said. And more importantly, they say that the activities carried on by the in the warehouse were an essential and significant part of the activity of the overall enterprise. And that is, if you look at Article 59 of, sorry, paragraph 59 of the commentaries on Article 5, that is actually one of the conditions that triggers, that an activity is a core activity and not of a preparatory or auxiliary character.
All right, well, I think this is a really exciting case because it's kind of like foresees and what's happening actually under BEPS and what happened under BEPS. But normally the situation, if you have a warehouse where you only deliver, you store, you have your merchandise, that really automatically we just say this is exempt because you look at paragraph 4 of Article 5. Literally, when you interpret it literally, it has nothing to say about, doesn't even require auxiliary or preparatory nature. It just says it's exempt, so it's really exciting. I think that was the big turn the OECD did under the BEPS project. Okay.
Actually, if you look at the new commentaries of the 2017 model, there is an example that actually is quite close to this one. So it's actually the example uses the same element of essentiality or significant to determine that this activity is not of a preparatory auxiliary character.
Right. I mean, indeed, one addition from my side. In that example, it is written that there are hundreds of people working in the warehouse, and there's significant assets are stored there, and so not just actually the nature of the activity, but also
the size.
So the size of the warehouse is looked at, and in this case, I doubt, but that condition would be met. But all right, I think it's great that we could highlight that for our viewers. So let's move on. Here you can see actually the decision and the indication. Let's move on. The next case actually concerns a local marketing service provider in France, the famous Google case. Emma, what do we need to know about this case?
Yes, so we've going around a trip around the world, and we return closer to the Netherlands and have a look at this Google France case that created a lot of attention last summer when it was released. And this is actually one of 5 different cases that was involving corporate income tax, withholding taxes, VAT, etc. So what we're looking at here, of course, is the question whether or not this Google Ireland had an agency PE in France. And these two are actually their sister companies. The Google Ireland is the principal, and they are the one who has the service advice, recommendations, and assistance. And then also from Google France, they have supporting marketing. But it's very important to make clear that they could not negotiate the agreements or licenses, or they could not either receive orders on behalf of Google Ireland. And if we move on to the next slide, all these facts that came out from the case. There was a lot of gathering of information in this case to see. It was very extensive. We see this in other cases as well, where the tax authorities go in to have a look at the LinkedIn accounts, for example, of different employees and see what kind of work descriptions they have. They're looking at new job ads, for example, and see what they're looking for, trying to see whether or not the activity that is performed in France, in this case, is actually something that creates an agency PE. And if we look at them separately, yes, in many cases, for example, we look at the very last one, it says the recurring mention in various Google France documents. They're using terms such as sales, seller, sales manager, etc. But of course, their argument in the case is that there are not actual sales carried out in France, and therefore they should not have agency PE. And it was concluded in this case, it was first instance, and it was concluded that because of this last part that we have on the slides, that the contracts were signed online by the customer and Google Ireland. So because of that, we're looking at the legal interpretation of OECD Model Convention, which says it has to be in the name of the enterprise. In that case, it is not then an agency PE. And they are specifically referring back to the Simmer case that was concluded in 2010. So we see still here that this is the case. We're looking at the legal interpretation, and it doesn't matter per se that they may have had some activity that was close to something we would call sales.
So essentially, if I understand correctly, the fact found by the French tax administration really kind of showed or indicated that his actual sales is done by the local entity, whereas the legal documents indicated that they didn't really have the right to conclude, let alone conclude in a binding way, the foreign principles into the sales that is made in France, right?
Yeah.
So that was it. Okay.
And it's very typical setup for many countries, and what we see everywhere. And of course, that was triggered the part of Action 7 of the BEPS project.
Right. I think we are going to talk a little bit about how it is changed. Indeed, I wanted to say that it is a common structure, right? So we have in the source country a marketing service provider who provides generic services to the foreign entity. Yep. It is remunerated on a cost-plus basis for the marketing, and it means that the sales is concluded essentially between the foreign entity, the foreign principal, and the local clients. And that means that the sales revenue from those concluded contracts actually go up and attributable to the foreign principal rather than a non-taxable in the source state. Okay, so let's ask our viewers whether they believe that the implementation of the MLI, so all these measures that the OECD put in place under Action 7, and now you can find in the MLI, will have an impact on future cases similar to the Google France case, so what we just actually described. So I'm going to roll out the poll for you. So now you have the opportunity to cast your vote and tell your opinion. Please click A if you think, yes, there will be significant increase of PEs and attribution of profits to the source state. So you think the MLI and the new measures will be successful and they capture this type of structures. B, if you think there will be significant increase of PEs, but only minimum increase of profits to the source state. So you think, yes, they're going to find a permanent establishment, but the attributable profit will be actually quite minimum. C, if you think no, due to the fact that Action 7 was not a minimum requirement, a minimum standard, so it's not a must for the companies that countries that even sign up to the MLI, there's not going to be significant change. And D, if you think it depends and future will tell. A few more seconds you have to pick your preferred option. All right, I'm going to stop the poll now and show you the results. So Louise and Emma, 67% of the viewers think that due to the fact that Action 7 was not a minimum standard, there's not going to be a significant difference, and essentially there's not going to be a significant impact from the MLI and Action 7. And 1/3, so 33% of our viewers thought, well, it depends on future will tell. What do you think about it?
Yeah, I guess they both kind of give the same answer, and I would agree definitely, because this is it's a typical example of what was the BEPS Action 7 was trying to have a look at, and trying to hinder these kind of structures. But of course, since it's not a minimum standard, many countries you see that they have opted out, even if they have joined the inclusive framework and they will implement the MLI, then you can see that many have opted out. For example, France in this case, they are just waiting to try to tax these structures. So they have opted in, but many countries, for example, we have Italy have opted out. There are many different countries that have opted out. Netherlands have opted in, which I just took an example because it's interesting to see. So should there be a similar structure like this between then, if it would be a principle in Netherlands with this kind of activity in France, it would be changed, because this really would, I really think in this situation, it would fulfill the new criteria.
Yes, that's what I wanted to ask actually. So just for those viewers who are not really familiar with the new text of Article 5, so instead of actually looking at the legal contracts and whether the commissioner or the salesperson on the ground can actually or should sign a contract or conclude a contract that's legally binding or in the name of the foreign principle, we are much more looking at the economic substance. Is he actually negotiating contracts, or plays a significant role that leads to the conclusion of the contracts that are then routinely concluded without material modification, right? So it's a much more practical approach actually the countries can take now under this new text.
But still, you know, when you look at the MLI, it is important to say that, you know, only almost 20% of the countries opted in, the rest opted out.
Yes.
Out of a large number of countries, that is an indication. It is not clear whether they just didn't want to jump into the wagon. They want to probably to see what's going to happen. You're going to discuss later about the allocation of profits to permanent establishment. And this is one of the things that has been actually in discussion, is how much profits should I allocate to these new PEs that are going to pop up once you start applying MLI clauses.
Right.
So the question is if whether or not there will only be more PEs, but as the earlier poll question, or this one, it will not be more profits attributed to France in this case anyway.
Right. If you properly remunerate perhaps the local entity, then that helps. Okay, we are going to look at profit attribution a little bit later. Let's go further. This case is about, again, India. But in this case, it's not a race court, it's about expatriates and people performing certain activities there for the foreign entity. Emma?
Thank you. This is an extremely complicated case. If you want to read it, this particular one, the GE Energy Parts Inc., is a chosen lead of the case. It's actually 24 different non-resident companies of this GE group that is part of the big case. It's 139 different appeals, and it's based on a survey that was carried out by the Indian tax authorities at a liaison office by the GE group in India. And at that place, they found out that they have had 7 expatriates working on behalf on different GE companies around the world. They were employed by a US company, not this specific company in this case, but they were employed by a US company. They were sent out to India, and they had different kind of lead functions. So they were leading different kind of business lines. So they were not working on behalf of specific non-resident companies around the world, but they were working on behalf of specific business lines. And they were working with a team that was employed by the Indian company. So they were working underneath them to carry out different kinds of activities. And in this case, the taxpayer then argued that they were only carried out these auxiliary preparatory activities, and the tax authorities in their case, they were arguing that it was the core business. So there was a question both whether or not they had a fixed place of PE based on the Article 5.1 in the OECD Model Convention, and the second question whether or not there was a dependent agent. And as you can see here in this case, these expats, they were there 2 to 5 years. They had also done all this research that we looked upon earlier. They looked at their LinkedIn accounts and saw what kind of responsibilities they had. They also saw then where they were at this place during the survey that they had their offices in India. They even had their names on these different offices. So when we're looking again at this this place of business and at their disposal, they had this. So then the difficult part of the case, of course, is for which company were they carrying out this business? And it was not possible to say exactly because they are carrying out business for several different principals in other countries. So it was determined in this case that they had a fixed place of business. In this case, we said the GE Energy Parts Inc. had a fixed place of business, but that also indirectly said that many of these other 24 non-resident companies also had a fixed place of business in India. And then also they were looking at its dependent agency PE. So they were looking at this two parts of this, which is very interesting. And they were participating in contract negotiations. They were actually not concluding contracts. So once again, we have this discussion that we had earlier. The other one is that they were, of course, working for several different principals. So in this case, you could not say exactly which principal they were working on behalf. What they did what the court did in this case is that they said that even if they had several different principals, they would see them as one unit because they were part of the same group. So also in the discussions regarding the dependent agency, so not an independent agency, they concluded that they had a PE in India, and even though they were not actually concluding the contract, they were part of negotiation and they had a substantial amount of say in the negotiations, which made them have a agency PE.
I think we covered that part of the discussion, so let's just for a second focus on the number of principles.
Yes.
In the pre-BEPS text of the OECD Model Tax Commentary, it is indeed actually indicated, as you suggested, that the number of principles is not decisive. So even if you have a lot of principles, it's possible that you are a dependent agent, or actually if you have only one principal entity, it's still possible that you are an independent agent, right? So I'm wondering whether, again, do we know that the OECD commentary was involved in any way, or international documents were used in the interpretation?
Not exact that I can say. Well, no.
Right. Okay. And looking at it, what's your opinion? Is that the right conclusion to say, looking at together, so using this post-BEPS approach? Because I mean, just for the viewers, this is again changed. So we have a new provision of independent agent, and that entails that if the agent actually has even many principal entities, but they are closely related enterprises, and there's a new definition for closely related enterprises in the text of the Model Tax Convention, then despite the high number of principles, still actually we just look through it and say it's a dependent agent. So they use the post-BEPS approach, which is possible because it's an interpretation, right? And I think even the commentary gives that room to the tax administration. But indeed, it's quite rare to say it's like that.
Yeah, the commentary gives you the right to well, not the right, but at least give you the opportunity to look at the independence from an economic perspective. So it's not just legally, but economically as well. So if you have the possibility, if you see that, you know, you can have several principles, but all these principles are related from an economical perspective, you can say that is, you know, you're dependent and not in a dependent person.
So we can actually kind of agree with the decision. This freedom was given to India. At least this element or aspect is correct. They can use this interpretation. Or you have another opinion?
No, I mean, I always have problems when you find a fixed place of business permanent establishment, but also you have a dependent agent permanent establishment. And I'm going to be discussing about it later, but with a Danish case. But
I see.
But I think it's a very interesting case also just from a business perspective, how you plan your business, because it's obvious that in this case, I think it kind of got lost because of the fact that they were working for business lines.
Yes.
They were not working on behalf of any foreign principles. And that is the risk, I think, when you have this. And of course, in the world we live in with expats and people sent around the world, it's very, very important to make sure that who is responsible, who are you working on behalf of, and especially now with BEPS, within that new action points, and everything will be different in all countries, because you have to check who opted in, who will be implement, who will have new tax treaties based on new OECD model convention. So it does create a chaos, and I think in this case, of course, there was some mistake, unfortunately, from the taxpayer, and it is, of course, you see that you have a business, because they were sales to Indian customers. It's, of course, we didn't say that specifically, but that is what's happening for all these non-resident companies. They are selling to the Indian markets, and they have people there who work on behalf of them.
Yes. Yes.
So of course, otherwise, all the profits will be attributed to the non-resident entities outside of India, although they are selling to the Indian market and their customers. Correct. So, in that sense, of course, if we look at it from a very high level, it really makes sense that some of the profit. And then, of course, we're not going to go into that specifically, but you can also see from this case that it's a interesting kind of profit attribution they have made in this case. It's very generalized percentage of revenue and then percentage.
There was an apportionment at the end of the day. There were no detailed financial
they requested it from the taxpayer, and they apparently did not receive it, so there was an apportionment of the
that's
profits.
Part of Indian domestic law is that they have a provision that when you cannot get enough elements to determine your taxable income, they will just guesstimate and put whatever they want.
Yeah, they based it on an earlier. There's an earlier case from 2011 that also a Rolls-Royce case that has the same kind of apportionment. So.
All right. Thank you very much, guys and Emma. Let's move to a bit colder climate, Denmark.
Colder climate and probably a less controversial position from the tax authorities. This is a ruling from the tax authorities. In this case, we do have a German company. This German company was performing construction services in Denmark. The business was going so well that they decided to hire an employee, a Danish employee, and this Danish employee actually rented an office space. And this employee was just looking for potential projects, doing marketing for the company. This employee was attending trade fairs, giving exposure to the German company. In no way this employee was selling or binding, the German company. No surprise, the tax authorities, they figured out, they started the decision and say, there is a place of business because there is an office space, and there is a person actually working there. However, when they look at the type of activities, they found that these activities were the typical of preparatory or auxiliary character. So the tax authorities determined that no PE will exist in Denmark for the German company.
Right. If you talk about the case again and the pre-BEPS analysis, it looks to me that you talk about collection of information, right, and promotion, so marketing, right. In the pre-BEPS text, if you look at paragraph 4, it says this kind of activity is essentially automatically exempted because they are kind of mentioned, especially the collection of information. So then BEPS comes and says, no, now from now on, you can't just automatically exempt by definition certain types of activities that are listed there. You have to look at it whether they are significant in light of the non-resident entities' overall business. Let's assume that the outcome of the case is different. So would that be then BEPS make a difference? So if you say originally the decision would be it's actually a significant activity?
Well, I think that, with BEPS and the new rules, definitely you need to reassess PE
Right.
risk. It's something that even in the most benign cases, you have to do it. Although, I mean, from the cases, from the facts that we found here, I think it's a bit
Yes.
difficult, a bit remote to say that we're gonna have a PE here.
Right.
But of course, you never know. I mean,
Yes.
there is always a risk, and you have to assess that particular risk to the specifics of every situation, I will say.
Indeed. I mean, looking at it, it's a construction company. So whether it's a question whether this type of activities actually would in any way result, would be characterized as significant functions. All right, let's move on. What about the second Danish case?
Oh, the other is also interesting. It's also a German company. And this company manufactured equipment, technical equipment, and they commercialize this technical equipment, but also provide technical services related to this equipment. Again, the same country, Denmark, they want to improve, they want to sell more in Denmark, of course, and they hire two persons. One person is a salesperson, and this salesperson actually will not the company will not pay for an office, but this salesperson is going to be using his home office. So the activities that he performed in his home office was pretty much fact-finding. It was doing market research and so on. However, outside of the scope, he was visiting clients. He was, demonstrating, doing some marketing about the machines, the benefits that the clients can get out of the machines. And they also, they were taking orders, sending the orders to Germany. All the orders were approved in Germany. However, they had two types of machinery. One machinery that was the plain vanilla machinery, let's call it this way. And for that, the salesperson will have a list of price, and it will actually be able to give certain discounts. With more complex machinery that required a little bit of tailor-made for every customer, they will pass all the information to the German office, and the German office will be able to provide pricing and actually any discount. So there was pretty much not much involvement from the salesperson. During the negotiation of contracts, the salesperson was involved, but he was involved because of a linguistic issue.
Right.
Of course, it was helping in that sense, doing translations,
Yes.
helping the parties to put together. But at the end of the day, the decision making was always in Germany. There was another person, the service person, and the service person was actually helping the company or helping the clients once they received the machinery to set up the machinery and also provide after-sales services like warranty. If the customer has a problem with the machine, they will that technician will solve the problem with or without the remote help of the German company. If it was a complicated problem, the head of the technical division of the German company will be on call. Most of the spare parts were sent via courier to the technician, so there was no inventory in Denmark. And there was no office for this person. This person always worked in the premises of the client, and this person never worked in the home office of the salesperson.
Right.
However, when the tax administration started to look at Article 5.1, because they started the analysis with Article 5.1, the place of business permit establishment, they look at the home office of the salesperson. They say, well, that's a place of business, even if only the activities that were carried in, they were limited. to fact-finding and finding information of potential clients. So what they found, they say, well, this home office, even if the no reimbursement of expenses was made to the salesperson by the German employee, they consider that this was a place of business, and the activity of the German company was carried on through that place of business. They never discussed, or they mentioned that it was not relevant, that the office was not available for the German company. They say, well, this is not relevant for us. And they actually merge together the activities of the salesperson and the technician, and they allocate all this to that fixed place of business, creating a permanent establishment.
Right. All right. I think this question, this case raises many questions. I mean, if I hear it first, the home office problem about that, and you mentioned actually the 2012 discussion draft that were issued by the OECD, and then they extensively deal with the idea whether a home office can create a permanent establishment. But it seems to be that overall the countries that are actually signed up or took part in that discussion draft, they look to me like they're not considering having a PE, or that the home office can create a PE. So they would say this is not the case, since the foreign principal doesn't have actually control over your home. It's not like they have the home at the disposal, or they can just effectively use your living room, your kitchen, and then do business there. On the other hand, I remember that Israel and some other countries took the position actually that, looking at from an economic perspective, they indeed can reimburse your costs. They can purchase you assets there that you can store there, so there can be something. So it looks to me, that most of the countries wouldn't consider it because it's a home office. They wouldn't even actually then go on to examine whether it's an auxiliary or preparatory activity. I think that's also a good argument to use, that a home office can't create a PE since your activity is outside of it. The sales activity is not in the home office. It's just documentation and other preparatory activity. And the other question is actually, maybe it's also interesting, the combination, so that the fact that the activities of the sales and the service person was combined, it looks like an anti-avoidance kind of approach the Danish took in this regard.
It is interesting. Let's start looking at the home office. And, indeed, many countries, including France, for example, that comes to my mind, they found if there is a reimbursement of expenses, like telephone, internet, whatsoever, that home office can be a permanent establishment, because it is pretty much at the disposal of an employee of the company, which is
the person who lives
his
there.
office. Yeah, exactly. And interestingly, when you look at the ruling, they're quoting many rulings from the Danish tax authorities, that whereby a home office can be considered as a permanent establishment. So it's a recurrent theme in Denmark. The other part, it's interesting that they actually, even the activities are not necessarily interrelated. I mean, the salesperson was never working with the service guy. But as a whole, it makes sense, because the company is selling a product and is giving after-sale services. So you can see that
the link there.
It can be a combination, pretty much a la BEPS, as we have here.
Correct.
The interesting part then to mention Denmark is the ones they have opted out of 90% of the article that refers to PE. In that. So,
well, no need if in either way you can conclude and arrive at this conclusion.
There is one thing though, and this is very interesting, and they also thought, because we have a person concluding contracts somehow and helping in the negotiation of contracts, whether the tax administration will also like to look or opt for agency permanent establishment. And I think that the Danish, they did well here. They say, well, if we look at the commentaries of the OECD model, they say that, let me read these. It's the Article 5, the paragraph 5 is an alternative test. So if you don't find a permanent establishment under paragraph 1, then you can jump into 5. But here the tax authorities, they say, well, we found that there was a permanent establishment under Article 5.1, so we're not going to be looking at the agency PA because it doesn't make any sense.
A very taxpayer-friendly approach, I think.
Well,
from
yeah,
the,
actually,
from the
but
Danish guys,
it makes a lot of sense because it's what the OECD model says. So.
All right. Well, thank you very much, Luis. Let's move on. Let's have our third poll question. I'm going to open the poll for you. It reads as follows. In your everyday practice, do you feel uncertainty when it comes to the current legislations and the creation of the PE? So you can perhaps consider post and pre-BEPS as well. So current legislation. So please click A if you think no, I don't feel any uncertainty. B if you say no, I don't feel any uncertainty at the moment, but expect there will be increased uncertainty in the future. And C if your answer is yes, I do feel uncertainty. Going to wait a little bit more so everyone casts his or her votes.
I'm not a futurologist, but I can imagine what will be the answer here.
Right. Let's. All right. I'm going to stop the poll and check whether Louis' projection is correct. So I'm going to show you now the results. So 100% of our viewers think that they do feel uncertainty. Yeah. Right.
No surprise.
No surprising here.
No.
No
Okay.
surprise.
But I hope our webinar has actually clarifies a few elements of the PE discussion.
Or not.
But
just shows how much problems can arise.
Right. It scares people
that's
about the
point.
topic.
Yeah, no,
Okay.
absolutely.
The sad part of it, of course, is that BEPS was the plan was to make it more equal, to make it more certain for businesses.
Right.
But because of the fact that it was not a minimum standard, of course, this creates more uncertainty because not only have to look at all these cases and see what has been decided on pre-BEPS, but to add on also the aspect to check whether or not countries has opted in or not, and will update or use the MLI to update the treaties.
Right.
So it will be a little bit of a chaos, I would call it. So you really have to make sure.
No, it's definitely a challenge, I think.
Yeah.
Absolutely. If you're a multinational and looking at, activities in 200 different countries and then trying to map and trying to find, the right solution.
It's very consultant friendly.
No,
Yeah,
absolutely.
let's put it this way.
I believe that actually BEPS is creating a lot more of uncertainties, and not just on the PE side, but in many sides. It's going to take a lot of years of practice to settle many of the things that are still in the air with BEPS.
All right, then let's move on and let's examine actually whether the profit attribution side is a little bit more clear for our viewers and for us as well. So we included this slide that is essentially an overview about relevant PE developments, and you see essentially it bridges the gap between 2004 and 2018. So we talk about 4 or 5 years of legislative work from the OECD on the matter, which I think already shows and exhibits the delicacy and the complexity of the matter. There are a lot of discussion drafts and final papers. So essentially BEPS Action 7 started in 2014 October. It was closed in 2015. So the discussion about Action 7 and Article 5, essentially the PE threshold, it is closed. So we can say that this is final. However, meantime, the OECD opened the discussion around the attribution of profits to permanent establishments. That wasn't really the original intention. So if you read the first draft, the OECD indicated that the fact that they changed the threshold of the permanent establishment doesn't actually necessitate significant change to the way we attribute profits. However, the paper mandated further clarity and guidance, so the OECD promised the tax community that there will be further guidance about attribution of profits. So they issued the first paper about this topic in 2016, July, and then 2017, June the second one. And then 3 weeks ago, the third paper, additional guidance and attribution of profits to permanent establishment. If you look at these guidances, the first one actually is a very practical one, very technical one, and it includes a lot of numerical examples. The second one, perhaps due to the high number of comments the OECD received on the first discussion draft, goes another way and has another approach. It only talks about high-level principles, doesn't get into details, it doesn't really give practicalities and numerical examples. And then the third one essentially follows the same approach as the second one. So again, we're looking at principles, we're looking at no numerical examples, and I think certain kind of criticism again can be leveled to the OECD for the work. Importantly, it is an agreement between the inclusive framework members, so those countries that are part of this club of the OECD. They also indicated that the approach the OECD takes is always clear. It is the separate and independent enterprise approach. So whether someone or a taxpayer or the actual treaty is under the impact and under the provisions of the so-called authorized OECD approach, the new approach of profit attribution since 2010, or it follows the old Article 7 provisions prior to 2010, it doesn't seem to matter for the OECD. They say how we attribute profit to the PE is always that you have to follow the separate and independent enterprise approach. So let's go a little bit more details about it. They offer illustrative examples. Some of the examples concern the paragraph 4 changes, the new anti-fragmentation rule and the attribution of profits under this new paragraph 4.1. Some of them concern sales activities, and some of them purchasing and procurement agent and attribution of profits to agency and permanent establishment created by that procurement agent. So the first one is really about the new anti-fragmentation rule, and again, it doesn't really get into detail. So it describes actually more like this analytical framework under which we can attribute profits to the PE. So in this case, what the OECD provides is online code that purchases and sells products through an online platform. It has an office and a warehouse in the source state. There is no pre-existing permanent establishment, and none of them, neither the office nor the PE nor the warehouse, constitutes the PE prior to the BEPS tax. So the new anti-fragmentation rule, however, kicks in according to the case, and then suddenly, of course, we can find a permanent establishment, due to the fact that this anti-fragmentation rules that says that if there are many fixed places of businesses and the activities that are conducted through those fixed places of businesses are complementary activities and are part of the same cohesive business operation, then you have to look them together. And then you have to look at either, and that's option A, whether there's already a pre-existing PE. In this case, that's not the case. Or option B says that if there is no pre-existing PE, then look at the activities together, whether the overall nature of the activity, the combination of the activity is more than and goes beyond simple auxiliary and preparatory activity. And this is the case in that example that is provided. So the OECD says in this example there will be 2 permanent establishments. Concerning actually profit attribution, the OECD says, well, due to the fact that neither the warehouse nor the office actually gets access to third-party revenue because the sale is done by online co in an online platform and in country R, you have to look at it how much actually service fee the online entity, the online co, would pay actually to the office or the warehouse if they were separate and independent enterprises. So if, let's say, the same service what is conducted in the office or in the same service is conducted in the warehouse would be done by independent entities, how much profit that entity would earn actually for those activities. So more or less this is actually how the OECD looks like. Are there fixed places of businesses? Is there a PE prior to the conversation? No, then look at together the activities together and then attribute the profit to separate and independent enterprise would earn. I think it's rather clean. Then, of course, we have a dependent agent permanent establishment example. Actually, there are 2 examples. One of them is classic commissioner example. We talk about commissioner structures, and the other one is sale of and certain marketing and sales activities that are going on in the source states for an online sale entity, again an online entity. In this case, we have TradeCo. TradeCo buys and sells widgets or gadgets. It has actually a related party, SellCo. SellCo conducts marketing and sales activities as commissioner. Or an alternative example would be if this entity wouldn't actually conclude contracts, but habitually play the principal role, so essentially negotiate the contract that leads to the conclusion of the contract between TradeCo and the country S customers. So essentially we have SailCo that acts as a sales commissioner of TradeCo, creates a permanent establishment under the new Article 5 regulations. Then what happens? Then we have, of course, two taxable entities. First of all, SailCo, that is an independent enterprise and a legal entity, actually. And then you have to look at it, how much profit or how much actually the attributable profit to that sales entity was, the remuneration of that entity. And that is essentially an Article 9 question. So you have to look at it if you have a commissioner, sales agents in the source state, what is the arm's length price, what is the commission fee that this entity in this example, SailCo, would earn actually under independent market conditions. And then the other question, of course, how much profit is attributed to the PE that is generated by SailCo, and that's an Article 7 question. And here the OECD follows the authorized OECD approach. So they look at it actually a functional analysis, what is happening at TradeCo level. TradeCo is essentially purchasing those widgets and selling them. What's happening at the PE level? The PE is responsible, actually the country, as sales. Besides that, the permanent establishment is also actually conducting inventory management. That is considered to be an economically significant function. So it means, those of you who are familiar with the topic, that the inventory as such will enter up in the balance sheet actually of the permanent establishment. And then the second step, looking at the transaction between the parties and the remuneration. So essentially the PE will be looked at as a local buy-sell distributor. We are going to look at it, the transaction between TradeCo and the PE is a sales of widgets from TradeCo to the PE, and then of course the PE is going to sell it to the local customers as well. So accordingly, the revenue of the PE is going to be the sales that is realized from the local country as sales by the permanent establishment. So in this case, the PE gets access to the third-party revenue, and the expenses the PE needs to pay is essentially the widgets, so the price it paid to TradeCo, right, for the widgets, because it bought the widgets from TradeCo and sold it in its own name as a distributor. And of course, the PE also needs to compensate the sales activities that are actually done by the sales guys sitting at SailCo, the local entity that is created, the permanent establishment. And the question comes then, once we actually remunerate SailCo under Article 9 with a arm's length remuneration and commission fee, then is there any kind of profit that is still attributable to the permanent establishment? And the problem is, again, that the OECD indicates that in some cases the profit that's attributable to the PE in this case can be minus, positive, or nil, but it doesn't actually get into detail. So it's never actually mentions a case where the actual profit that is attributable is 0 or minus or plus. So it doesn't really get into the bottom of the conversation, and in substance doesn't really unveil this most crucial issue. And the other problem is about, and those of you who are familiar with the topic, is about risk allocation. So of course we have an Article 9 relationship, and if you know that we have the new OECD transfer pricing guidelines from 2017 that looks at in the Chapter 9 how actually risk is assumed by the parties contractually and of course in terms of their conduct, whether that respects the contractual allocation or not. And under Article 7, we have a definition for significant people function, and if you perform significant people function, then risk is allocated to that entity. So we have two different definitions. They are not aligned. They're risk assumption, control management under transfer pricing, and we have the significant people functions and the risk allocation until then. And the OECD described that these are not the same definitions, but doesn't really in detail elaborate and doesn't give an example what would happen when risk is assumed by the permanent establishment, but financially the capacity can't bear by SailCo, then shall we reallocate the risk, or what would happen? So again, I think it's a missed point, and I'm sure actually the comments the OECD is going to receive on this example, going to well, ask for more clarity on that point. So in that regard, this doesn't really add a lot, this discussion paper, to the canon we already know about profit attribution. It gives a little bit more detailed description of the cases, but in terms of profit attribution, unfortunately, it's not the Saint Grail we were looking for. So that's about this example, and the next one is about procurement agent permanent establishment. let me here start with the facts. We have BICO, again, that is a related party of TradeCo, the non-resident entity. Its role essentially is to negotiate purchase and procurement contracts on behalf of TradeCo. So purchase products, essentially negotiate those contracts on behalf of TradeCo for purchasing raw materials or semi-finished goods, for example, in state S. We are going to apply here Article 5.5. So despite it's not a sales agent, you can apply the definitions because you have an entity that concludes contracts or negotiates those contracts on behalf of the non-resident entity, so creates an agent permanent establishment. In this case, it's not a sales agent PE, it's a procurement agent PE. If you look at, again, because we created a PE or BICO created a PE, we have to conduct a functional analysis. It also shows that the PE actually is responsible, and BICO is responsible in this case for the inventory management. Again, that is again a significant function, so the inventory and the inventory risk will end up on the balance sheet and the P&L, of course, of the PE. But in reality, again, we have an Article 9 situation between TradeCo and BICO. So first you need to actually compensate BICO for the agency services it provided, and then you look at the attributable profits to the permanent establishment. In this case, the PE as such does not get access to the sales that is done by TradeCo. So TradeCo is doing the sales in state R, so the PE doesn't get access to third-party revenue. So the sales that is done by the revenue attributable to the PE essentially is the amount that TradeCo would have to pay to a third-party supplier for the widgets. And the costs of the PE include the arm's length remuneration of BICO, and of course, because it looks at like a third-party buy-sell distributor who purchases products and then sells them to TradeCo, the widgets price is also deductible from the profit of the permanent establishment. So this is essentially the analysis the OECD gives. There's not a lot of question here. I think in this example, the only difference between the previous example, the previous discussion graph example, and this one is the inventory management from the level of the PE. A little bit more details, but in a sense, I think we kind of agree with the analysis the OECD provides. So that is about, I wanted to show you these three examples about the new discussion draft, and this is time for our fourth poll question. I'm going to open the floor for you. Where do you expect the most changes going forward when it comes to the creation of permanent establishments? So this is really the question. Which aspect of the PE essentially you think to be the most crucial or risky from your perspective? Please click A if you think creation of more dependent agent PEs. As we discussed, we move from a legalistic approach, which looks at essentially whether the local entity concludes contracts or not, to a more economic approach where it looks at whether they actually negotiate contracts or in substance making deals on behalf of the non-resident entity. Click please B if the creation of more P is based on a modified specific exemption rule. So the fact that the auxiliary preparatory activities won't be automatically exempted, but you have to look at it and conduct a kind of like a transfer pricing analysis, look at whether those functions are significant or not. C, if you think creation of more P is based on the new anti-fragmentation rule, so when you look at what's happening actually in the state of investment and you can add the activities together if they are complementary and they're part of the same cohesive business operation. D, if all of the above, and E, if you don't expect any significant changes. Luis and Emma, what do you expect?
I will give you the proper lawyer answer.
Right.
It depends.
Right. You spend too much time in the advisory sector.
Absolutely. You know, if I have to generalize, would probably choose D. But you know, some countries will actually, you know, you will have more agency permanent establishments. Yeah. I mean, there has been all these war against commissioner structures, which, well, I have my own opinion on those, and we will have to deal with this paper on attribution of profits to permanent establishments. That when I look into it, I was a bit disappointed. I thought like the third one is the good one, but I was suspecting, you know, if the OECD cannot provide numerical examples, what else? What is left for the rest of us?
Yeah, I think we are the ones that need to provide a solution. I think we are for the tax committee. All right, so let me show you the results. Essentially, we have a 50-50, so it's again a tie as a draw. 50% of the viewers think that the creation of more PE based on the modified specific exemption rules, so we're talking about warehousing and other activities. And the other one is this kind of like the safe option, all of the above. So, all right.
It depends also, of course, the behavior of the tax agencies where they decide to focus on. And I think if they are smart, they will go where they see the most profit, of course, not the collection. There's no need to collect PEs. Just a compliance burden for the taxpayer is really where you get more tax revenue for the source state. So
correct. I think the example showed that we talk about warehousing operations, purchasing agents that don't actually do business, right? So they are back office functions, or they are cost centers from an accounting perspective. So the attribution of profit will be really possibly minimum, but there can be significant VAT consequences or significant customs consequences. So I think that is something that's going to cause headache for the viewers. All right, so let's move on and talk about the European Commission and recent developments at EU level. As you can see, 21st of March was a very busy day in Brussels. The European Commission actually published two proposals. The first for a council directive laying down the rules relating to the corporate taxation of a significant digital presence, and the other one is a tax on revenues resulting from provision of certain digital services. So essentially there are two solutions in the digital economy sector that are provided by proposals that are provided by the European Commission. The first one, and I would like to start with that very briefly, is the interim solution. Essentially it's a 3% tax on revenues that are created via certain digital economy activities and digital services. It's important in this case that those companies, multinationals, are concerned that activity and overall revenue actually goes above 750 million, and they make around 50 million euro, more than 50 million euro from sales within the European Union. It's important that the tax can be collected by the member state where the users of those services are located. So it's really an interim solution. It's an indirect tax, essentially following other indirect taxes applied by certain economies. We see this trend actually in the world to tax digital economy companies. And of course, the activities that are concerned, for example, are those that are related to the sale of data generated by users, or for example, the online promotional space that is sold by certain digital economy giants. So this is the interim solution, and we're not going to really deal with this. The more exciting for our purpose essentially is significant digital presence. So that's where the European Commission actually creates something really new. It's the virtual permanent establishment concept. If you look at the slide, it gives you an example. We have Online Co that supplies digital services through this digital interface to users in member state S. And in certain cases, if certain conditions are met, that service actually could create this virtual PE, a significant digital presence through which this business activity is carried on. What are these conditions? So Online Co will have a significant digital presence, aka a virtual PE, in the member state if, together with its associated enterprises, the sales revenue exceeds from these activities more than 7 million euro in a tax period that is supplied to local users in member state S. B, if it has more than 100,000 users in member state S in the tax period, or it concludes more than 3,000 business contracts for digital services. So the contracts are concluded between Online Co and users located in a member state S. So essentially 3 thresholds, one of them should be met, and then the entity Online Co is going to have a virtual permanent establishment. Of course, the European Commission describes this rule a little bit more detail, not a lot of detail, but a little bit more details. So furthermore, the new proposed provisions can be applied if there's a unanimous decision at the level of the European Commission. So all the 27 remaining member states after Brexit agree with this new proposal, then it can be applied from 2020. It's important to say that it would be applicable, this new directive, to EU companies, so companies that are actually located in the European member states, or they are located and resident in a third country, so for example in the United States, somewhere else outside the European Union, provided actually they have a double tax treaty with the EU member state concerned, and that double tax treaty, the double tax conventional agreement, has a similar virtual PE provision in the DTC. So in case, for example, you have a Russian company, you have a Ukrainian company, nothing to be afraid at this very moment until virtual PE provision is inserted and stipulated into the treaty between Ukraine, Russia, and the European Union and one of those member states. It's important actually that this is going to be, this virtual permanent establishment provision is going to essentially complement and supplement the already existing PE test. So it's going to be somewhere maybe described and in the directive how it looks like. So essentially you will need to have to go first to paragraph 1 of Article 5, looking at the fixed place of business, then maybe agency permanent establishment, perhaps there's some kind of service permanent establishment provision in DTC, and on the top of that you have to also consider whether a virtual permanent establishment provision is met or not. Importantly, the users must be located in the EU member state. That means essentially that you need to use the device based on data captured by the IP address or any other geolocative method in the EU member state. So even if a third country individual enters into the member state and uses his or her device to get access to the digital platform, then the provision of service actually via that platform is, and that condition can be met, and the revenue condition can be met. So that person will be one user in the European Union, despite being actually a third-party national. What is a business contract? So one of the conditions, as you remember, is that more than 100,000 business contracts are concluded. Well, if you know the expression B2B contracts, essentially from VAT perspective, that's what we are looking at. So that the customer in this case uses the contract for carrying on business in the member state as and its resident enterprise or resident enterprise for corporate tax purposes in that member state. So these are essentially the explanatory notes. What about attribution of profits? Obviously, if there's a permanent establishment, whether it's virtual or not, you have to be able to attribute profit to that PE. So the European Union provides rules for that as well. They first of all indicate that attribution of profit concerns only corporate tax measures and the corporate tax framework. This essentially means that whether you find a permanent establishment and attribute profit to that, it's irrelevant for VAT purposes, for example, or customs purposes, for example. The guiding principle here is the separate and independent enterprise approach. So essentially the approach that we use for non-virtual PEs, but traditional permanent establishments as well. The method here again is the same. You have to first start with a function analysis. So this is essentially the same. You have to look at functions, assets, and risks that the parties, the PE and the non-resident principal head office entity, what are they conducting, what type of risk are they assuming. Now you know that in a traditional attribution, so when we attribute profit under traditional physical place of business, the guiding rule is there a significant people function that is performed at the level of the PE or the head office. Now obviously a virtual PE does not have employees or does not have people in the cloud. So the European Commission came up with a new idea, is the economically significant activities. So if this virtual PE conducts economically significant activities, then it will also receive certain risk and assets from the balance sheet of the head office accordingly. And what are economically significant activities? Well, those activities, for example, that are related to data and users in relation to these activities that are conducted through the platform, including, for example, the DEMPI functions related to intangibles with regard to digital economy activities. And at the end, so you find a permanent establishment, you attribute profit, you need to essentially remunerate the permanent establishment based on the assets, functions, and risk that you just allocated to it using the economically significant activities. And you need to use either the profit split method for that or any other internationally accepted method or principle, depending on the function analysis. So you use the OECD transfer pricing guidelines essentially to do that. And of course, I think the different conditions, circumstances will determine which is the right method to attribute profit. But the profit split is definitely can be one that is useful and recommended by the European Commission. So in short, actually, that's how it looks like. What is a virtual permanent establishment? How you attribute profit to it? What type of methodology you are going to use, essentially. I think these are the things this directive describes. So, Louise and Emma, what's your opinion about the?
I can just say it's interesting, but I just keep thinking that what are the odds that it will be voted through?
Right.
27 countries to agree with the concept. We have a few without mentioning countries by name that for sure or most likely will not be positive to the directive. Yeah.
For me, when you look, for example, living a little bit outside the EU, but being a little bit more global, when you look at the interim report from the OECD on digital economy, you see that there is very little common grounds with all OECD member countries, which also many of them are part of the European Union. So I'm wondering whether this is gonna fly. I mean, if you looked at most of the high-tech companies or American companies, the US is one of those that say, well, we don't want to change anything now.
Right.
And if under the proposal of the Commission, if I understood correctly, you have to renegotiate the treaty and include that. I'm not seeing the Americans actually doing that.
Yes.
But it's part of the negotiation, of course, of the treaties, and let's see how it goes.
Right. I mean, learning from the example actually of the CCCTB or the financial transaction tax, where there were significant efforts made by the European Commission to push through those solutions, it looks to be that the result is really meager or kind of negligible.
But of course, there's a political pressure to do something.
Yes,
so of course,
that's important because I mean, even when you hear, the guys from the OECD or the European Union, they actually mention the political pressure, and that's something that is one of the major drivers.
Right.
And well, let's see how it goes.
All right, let's see whether it becomes effective and instigates the OECD actually to become a bit more assertive in terms of taxing digital economic companies. Right. All right, meanwhile, we rolled out a poll question. I think most of the viewers already answered it. The question was, are you positive as to the recent developments from EU with regard to the corporate taxation of significant digital presence, so the virtual P provision? And 50% of the viewers said, no, I believe there are better solutions, and 50% said, I have no formed opinion yet. So it remains to be seen. Again, it's not an overwhelmingly positive answer as far as I'm concerned. But let's go on. I think there are other important developments to discuss. Few examples from domestic law from Italy, United Kingdom, Australia, and then we're not going to talk about India, the equalization levy. It's more as a similar approach. Essentially, it's a withholding tax what India levies on certain digital services. But what about the rest? Could you talk a little bit about the Italian solution?
Sure. I mean, this is just as examples of things that has been happening. I mean, when you look at the first two slides, I mean, this one and the next ones, primarily we're talking about a regime that was introduced in mid-2007 in Italy. That was a cooperative compliance regime. And the idea was to determine the existence or not of previously undisclosed permanent establishment by big multinationals. So the idea was that a multinational, of course, which will be the multinational will team up with the tax administration and disclose their activity and together determine whether there is a permanent establishment or not. And which is the driver for the enterprise to do that? Well, it was reduced penalties. And funny thing is that they start to call it this web tax, but the funny thing is that the web tax came this year,
right?
So perhaps we can just jump. Yeah, exactly. In Italy for this year, we have first a new definition of permanent establishment under domestic law, and to the surprise of many people, Italy didn't opt in for the MLI for the PE provisions. However, under domestic law, they're implementing all these web provisions under domestic law, so which is a bit strange. And actually, they incorporated in their domestic law tax on digital transaction.
Right.
This tax applies to B2B transactions to service digital services, and it's a tax of 3%. So it's more an indirect tax which will not be limited by tax treaty.
So essentially, Italy looks to tackle this or address this problem in multiple layers, right?
Yeah.
So trying to find a permanent establishment, actually changing the PE definition, and try without the taxpayer, whether the taxpayer agrees or not.
Yeah.
And the third one is using a digital tax.
It is a bit confusing. I mean, what we're looking at in Italy now. But it seems from when you look at the discussions from the European Commission and the OECD, you see that there are some countries that really wants to jump ahead in dealing with digital economy, and well, that shows that Italy is one of those.
All right, well, let's see whether Italy will be able actually to use this new definition in the future.
Yeah.
All right, let's talk about the United Kingdom and the diverted profit tax. What do we need to know about this?
The diverted profit tax, it was created in 2015, and the idea was to create a tax that will apply when multinationals were actually setting structures that will circumvent taxation in the UK, whether they apply, for example, a commissioner structure not triggering a permanent establishment in the UK, or whether you use any other profit shifting strategy. So the idea is that the UK will apply a 25% rate on the income, and it has been applied in several occasions. I know that Google was targeted. Diageo, there was a huge assessment, or I think it was 100 million euros. So it has been applied. So and the idea behind this, because it's not income tax, tax treaties will not be able to limit or affect in any way other perhaps non-discrimination at how this tax will apply.
All right, so it seems to be that the United Kingdom has a different approach, different from the Italian approach, right? So Italy tried to make, for example, a compliance regime for that, and enhanced cooperation, hand in hand together, try to find a permanent establishment. Motivation is reduce PE.
Penalties.
Here is a little bit more about actually penalizing the taxpayer, right?
Absolutely.
And instead of actually trying to find a permanent establishment, taking the discussion out of that context and saying, all right, we couldn't find a permanent establishment, we're not going to negotiate or not going to actually deal with profit attribution questions, but then we are going to actually tax you under the
Remember that in the
tax.
2013-14, there was a lot of discussions in the UK regarding, Google and Amazon. There were all these grilling of CEOs, and that was the result of it. They wanted to do something, and they did it quite fast.
All right. This is an example.
Yeah, that's an example of the typical structure where you have a commissioner structure, of course, then avoiding an agency permanent establishment. In this case, well, the tax will apply.
Yes.
Because you're avoiding a PE, a physical taxable presence in the UK.
Right. I see. All right.
The other slide is similar, but instead of avoiding a physical presence, you're just using payments to have a huge deduction on the UK taxable base. So in theory, tax administration could actually apply that tax in these situations as well.
Right. Okay. I think some of the cases that you mentioned concern this type of structure, and tax base in the UK is eroded by royalty payments going out of the United States.
Exactly, especially in the EU.
All right. Let's talk about poll question 6 and ask your opinion about the following. Let me just roll out the question. So, what measure do you believe is the most likely to be the way forward with regard to the taxation of digital economy? So, we saw different solution actually from the European Union, Italy, and a little bit about the United Kingdom. So what do you think? A tax nexus concept of significant economic presence or similar. B, withholding tax on specific type of digital transactions. So kind of the solution India actually decided to go for. C, a digital equalization tax again. CCCTB, So there is, I think, the traditional topic pushed by the European Union, or E, it depends, any other solution. I'm going to give you a few seconds actually to cast your vote. So what do you think is going to be actually the most likely, so what's going to be the trend actually in the future? What do you guys think?
It depends.
Right.
No, but really,
Right.
it
Well,
depends.
maybe in the long term, I think that the proper solution, at least in Europe, will be CCTV.
Yeah.
Yeah, I think that makes it will solve a lot of problems,
Right.
especially on attribution of profits and so on.
Right.
But
then it's more who gets the part of the cake, the big cake.
yeah,
Right.
Yeah. So we're back to the same discussion.
of course,
but
I mean,
of
there
course,
is always
yeah.
a problem of sharing the pie, of course.
Yeah.
Okay, well, let's see. Going to stop the poll now and show you the results. Again, the votes are split. We have almost 33% to A, which is the nexus concept of significant economic presence, so the new concept is used by the European Commission. B, a withholding tax, and E, that it depends other solution.
Yeah.
So I think the viewers are also split. We'll see.
We don't have it here as an alternative, but of course we can also talk about indirect taxes.
Right.
That's the way to go. That the whole
correct.
corporate income tax system is not really made for the kind of businesses that
No,
is
you're
carried
absolutely
out.
correct. I think customs laws and VAT laws are all, already actually have been modified in several countries to tackle this type of importation of digital services, and the providers actually need to register in the local country and then pay local VAT and customs on it. So
You
I
have
think
examples in Japan,
good,
India, for example.
Indeed, Taiwan, I think Australia, European Union, of course. So it's important. All right, let's go on and talk about Australia and the MA. What do we need to know about that?
Australia is an interesting country. They have a really professional tax administration. And they do have a diverted profit tax, as in the UK. Actually, they copied that model. But they also have an anti-avoidance provision called the multinational anti-avoidance law, which is called MAL, and entered into force in 2015 as well. And I can summarize this, in a nice and easy way. If you are, somehow affecting your tax base in an by aggressive structures, the anti-avoidance provision will create or will trigger a deemed permanent establishment in Australia. Therefore, of course, all that income that escaped because of the tax structuring will be picked up by this deemed permanent establishment in Australia.
So if I look at the slide, actually, this is the kind of Google France case we talk about, right?
Exactly.
So it's a foreign principle. In that example, it was Ireland and the local service provider, marketing service provider.
Exactly.
In France, the French tax industry couldn't actually prove that there's a permanent establishment. Then the discussion went to BEPS. We modified Article 5.5, so the dependent agent definition, to capture perhaps this type of entities. But it looks Australia actually precluded and went forward actually, and again took a much more anti-abuse kind of approach.
Yeah, actually, when you look at, for example, UK with a diverted profit tax, the thing was the UK, the first one, or one of the few countries, saying with the MLI, say we're not going to jump into the new PE rules wagon because, well, we already have our anti-abuse rules, so we don't need that. So.
All right, well, it remains to be seen actually which method is going to be the trendsetter, which is going to be the most popular and have the biggest impact on this type of structure. I think our time is up. That leads me to the last slide, and thank you very much for your excellent participation, Emma. Louise, it was really a pleasure to have you here for the webinar. For our viewers, a few call to action points. If you like actually this webinar and you would like to follow the next one, which is going to be organized on the US tax reform, especially we are going to look at actually the implications, what those new provisions in the US tax code mean for the rest of the world. Then please click there and subscribe. You can also subscribe actually a webinar that we ran a few months ago that concerns the PE risk in international tax planning and structuring in the post-BEPS era. In that regard, we looked at more in detail actually the new OECD Model Tax Convention, the Action 7 points, and there also we dealt a little bit more in details about the attribution of profits to permanent establishment. In case you have not obtained the slides that you would like to get them, just click on the slide and download them. That is available. All right, so thank you very much for your active participation and attention. Don't forget there's a survey coming up after we said goodbye, so if you have some time, please bear with us and fill the survey. Otherwise, thank you very much and have a nice evening. Goodbye.